48 days without food to change India's map back in 1952. It was Potti Sriramulu who decided to fast, and he died on the 58th day. And this is what we are seeing yet again in our country. To bring a huge reform, we are seeing yet another political fasting, where Sonam Wangchuk is on the 19th day of its hunger strike in a land where this protest continues to bring in educational reform and the resignation from our education minister. But the bigger questions are here. Is the hunger strike legal? Why is the government not giving any answers? What are the limitations of court? And if government wants, can they force feed Sonam Wangchuk under the legal framework? Hello everyone, welcome to Vajram and Ravi's Flash News. My name is Shubhangi Singh, and in today's session we are going to understand that how come India is the land of political fasting, where hunger strikes are important. Empty stomachs are the ways to restructure the democratic demands that are made by public. We will be also understanding that how legally this hunger strike stands in the whole democratic framework. Can the government actually come to force feed and end hunger strike on different means? And most importantly, we will also be looking into what is the global framework around such situations. So let us begin to understand that why Indians continue to reach instinctively towards hunger strike. Because unfortunately, as Ramchandra Guha said, that when we are talking about Potti Sriramulu, he is a forgotten name, but his empty stomach is the reason that we are seeing world's largest democracy with states. This was the first time that we got a region state for Telugu speakers, and that is when Andhra Pradesh was created. When we are looking at, we get to see across the years that this is not the first time that we are seeing a climate activist, Sonam Wangchuk, sitting on the hunger strike. Over the years, our country has been shaped by such strikes which have yielded result. Be it Potti Sriramulu, be it Mahatma Gandhi, be it Anna Hazare, or be it Irom Sharmila. When we are talking about fasting, it is one of the oldest traditions that we have seen in India, especially as a form of non-violent form of protest. And its roots are coming from Hinduism, Jainism, so religious angle is also present, and it also comes from Mahatma Gandhi's Satyagraha, where it has yielded results more as a moral weapon rather than going for any sort of physical coercion. And in this very context, it is very important for us to establish right here that when we are looking at hunger strikes, they are becoming more and more enduring instrument of democratic dissent in India to show that this is not working, this is what we want. And we have a very solid reason that why hunger strikes which worked for Gandhi are working today as well for Sonam Wangchuk. So when we look and understand the reasons behind it, we clearly get to see that there are solid reasons which ensure that fasting remains a very powerful tool for non-violent protest. First, as I mentioned, we definitely take it from the Gandhian legacy of Satyagraha, where it has been shown as a moral weapon and how it can yield results. And it was here where it was shown that voluntary suffering, it is something that not only appeals to the society, but it appeals to the state as well. And when you look at this reason, you will understand that the cause that Sonam Wangchuk is standing for, that has gained more traction, more understanding after the hunger strike began, because this is something that is appealing to general public and hopefully will appeal to the government as well. Apart from that, there is a deep cultural acceptance as well across the religions, be it Hinduism, be it Jainism, be it Buddhism, where when we are looking at fasting, it is a form of acceptable mean of showing dedication, devotion. It really shows the sacrifice and also self-discipline. So to an extent, hunger strike gets legitimacy, moral legitimacy in India because of the cultural reasons as well. This is not seen something as wrong at all. And when we are talking about the appeal to the state, this gives a whole bigger moral ground and moral pressure is created on the government where the demands are being placed. Because as the protesters' health gradually deteriorates, which we are seeing in the case of protesters who are standing and fasting with Sonam Wangchuk, including Sonam Wangchuk, who has lost 8 kgs of weight, the muscle mass is going away, and this is where public sympathy often increases and the government faces mounting moral as well as political pressure. And when we are looking at fasting or hunger strike, it is also usually seen as the end mean when there is nothing that is working out, which is applicable to this very situation. So given all the context, even they are meeting the situation, the hunger strike that is being created, the hunger strike that is being carried on by Sonam Wangchuk and other protesters, these all acceptable means show that yes, hunger strikes, fasting still remain a very relevant tool of democratic dissent and they are being very rightly used. But this is just one side view. There is a counter view to it as well, and when we are talking about father of our constitution, he has also said when we are talking about methods like fasting and civil disobedience, that is when they should be done with, because if not, then they are being used for wrong things. That is why he said that this is where we can call it the grammar of anarchy. He said that fasting, being rigid for something, is not right. It should give way to dialogue, it should give way to constitutional mechanisms rather than any sort of coercion, be it physical or moral. So this is where I would want to ask you, do you think hunger strike is the right way to protest? Because it creates moral pressure, moral coercion, and it definitely appeals, which can create momentum, but is this the right way? Now that we have understood that what keeps hunger strikes relevant in India, a bigger question is if they are legal in the democratic setup that we are looking at. So once we are seeing this, the first thing we need to understand and clarify right now that yes, they are legal. No constitutional provision or there is no law which prohibits hunger strikes in India. We have a clear constitutional basis, Article 19, 1A, which gives us freedom of speech and expression. If we decide to use hunger strike or fasting to express our dissent, to express our disappointment to the government, it can be one way. And Article 19, 1B, which allows assembling peacefully. So if a peaceful hunger strike is going on, then this is not something that is against the law or the provisions of the constitution. This is something that needs to be protected, and if there is any problem at all, reasonable restrictions can be placed. So yes, they are legal. There are rounds of conversation and including a petition which says that Sonam Wangchuk should be force-fed. That means he should be given food against his will. So is this something right that could be done? So first, in this context, we also have to understand back in 2021, Madras High Court had already clarified that hunger strike cannot be seen as an automatic attempt to commit suicide. Because Section 309 IPC was present previously, this cannot be invoked, which is related to attempt to suicide, and now as of now that also has been decriminalized. But at the same time, if this is not criminalized, suicide is not criminalized and hunger strike is legally okay, how okay is force feeding? As of now, High Court has said, Delhi High Court, that we should not force feed Sonam Wangchuk. There should be proper medical attention that needs to be given every day to him. But in this context, what are the relevant things that we need to know? So the first thing that we need to know here that there was a different position in terms of force feeding previously. And in this context, a good case study here will be Irom Sharmila. Now, when we are talking about earlier position, authorities did use Section 309, which I just talked about, attempt to suicide. Whenever protesters who were doing hunger strikes, they were arrested, and once they were in state custody, so as to ensure that they take food, they were force-fed also. How they were force-fed? Through the nasogastric tubes. That is something that has been done with Irom Sharmila, who was standing against AFSPA in northeastern states. She has been arrested multiple times and force-fed as well. Her hunger strike went for 16 years. Later, with gradual withdrawal of AFSPA, she also withdrew from the hunger strike and later entered into a political career as well. But this shows that this force feeding did exist. But if you look at the newer provisions, we have to understand that when Mental Health Care Act 2017 came, attempted suicide was decriminalized, and it was understood that severe stress could be present rather than any criminal intent when a person is attempting suicide. Then came the Bharatiya Nyaya Sanhita of 2024. This talked about section 226, which says that attempting suicide to compel a public servant may attract a punishment. So in this context, if you are looking at a hunger strike as an attempt to suicide to get a public servant to do something, there is 1 year of imprisonment, fine and community service. So if the government wants, they can play on this if they decide to ignore this. But if we are taking this in consideration, based on that section 309, which does not exist anymore of IPC, based on that, there can be no force feeding that can be allowed to Sonam Wangchuk. Now let us understand what Delhi court has said in this scenario. So basically a public interest litigation came in front of Delhi High Court. They asked that there should be proper hospitalization of Sonam Wangchuk, he should get immediate treatment, force feeding, and at the same time it should be ensured that we are able to save Sonam Wangchuk's life. What did the court say? The court clarified that life of every citizen is precious, and it directed that to ensure that medical attention to Sonam Wangchuk is given, clinical monitoring, and whatever necessary medical intervention is required, that will be taken. But the High Court did not order for force feeding. Rather than court acknowledge that this is his right to protest. When we are talking about Article 91, this is where court acknowledged that Article 21, right to life, what about that? This is where court gave the responsibility to the state, because this is where government brings in answerability, and court also brought in medical judgment. Now in the last, we'll straight up move to understand the global framework and ethics standards. So if we talk about IME, that is International Medical Ethics, the World Medical Association has a declaration of Malta, which clearly says that force feeding a mentally competent hunger striker is not acceptable who is voluntarily refusing food, and this is ethically unacceptable. And this is what raises constitutional debates. The one I have mentioned, Article 19 versus Article 21, state's power versus the power to protest, and more. Now, what are your thoughts on this? Let me know in the comment section. I'll be leaving you here with a prelims practice question. Let me know the answer to this very direct, easy question. Let me know the answer to this in the comment section. I'll be waiting for your answers. Thank you so much.